Hello and welcome back to In Your Defense. I'm attorney Steve Toland. We've been following some of the sweeping criminal justice reform, some of the proposed legislation that's been put forth as Texas lawmakers reconvene virtually. Another one, in addition to the George Floyd Act, is some proposed legislation to ban the use of no-knock search warrants. That's, of course, in response to the tragedy that unfolded under the Breonna Taylor death in Louisville, Kentucky. So Texas does allow no-knock search warrants. It's very limited in scope and circumstance. So I thought we would spend the next couple of series of In Your Defense talking about search warrants in general, how to hire a lawyer to attack the validity of a search warrant if you think it's been unlawfully obtained or executed, your Fourth Amendment rights under search warrants, and then we'll eventually get to this idea of a no-knock search warrant, what it is, how it works, and why it's considered very dangerous by lawmakers, law enforcement officers, and citizens alike. I think everyone agrees on that one. So first, what is a search warrant in Texas? It's just a court order signed by a magistrate that allows a police officer to look for a specific item in a specific place within a specific amount of time. And then if the officer does uncover that item in executing that search warrant, they're allowed to seize it and take custody and control of it. So let's look at the 5 necessary requirements for a valid search warrant in Texas. Number 1, it must be issued in the state of Texas by and through a magistrate licensed or duly magistrate, if you will, here in the state of Texas. Can't be from New Mexico or Oklahoma or some other state. Number 2, it's going to state where the police are allowed to search. So it's going to need to state with some specificity the address, a reasonable description of the property if the address isn't quite known. It's got to state with enough specificity that you know exactly where it is police officers are allowed to go, and it's got to narrowly define that area. Number 3, it needs to state what it is you're looking for. You can't just say, I'm going to go in there and ransack everything, kind of like the British government did, which is how we came up with the Fourth Amendment in the first place. So that's the third thing. It needs to state what it is officers are allowed to look for, what they're hoping to find. And then number 4, it needs to state the date and the hour the search warrant was obtained. Why is that? Well, because there's generally a 72-hour or 3-day rule. Now, there are exceptions. For DNA evidence, officers have 15 days. And for computer devices or data that's electronically stored, officers have 10 days. But as a general rule, the 3-day rule applies because you don't want stale or stagnant search warrants. And then number 5, it needs to have the name and the signature of the magistrate who signed the search warrant, because you might want to ask them what it is the officer swore to as an affidavit. So that in a nutshell is the 5 necessary requisite elements for a valid search warrant in Texas. There's a lot more to it, though. There's an affidavit that accompanies that. So we're going to talk about that next on In Your Defense as we move forward through search warrants. If you have any issues with arrests or challenges or questions about valid search warrants or your Fourth Amendment rights, reach out to me, attorney Steve Toland, or us here at Pekin Toland. Thank you.